Hello there and welcome to Courts This Week. I'm Dina Osha. In this special edition, we bring you top stories of the legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We also bring a selection of major legal proceedings which made headlines this week. In this next half an hour, we will inform and update you of all the important proceedings from the week. So let's start Courts This Week. The Supreme Court has upheld the rights of the erstwhile royal family of the Travancore in the administration of the Sri Padmanabha Swami Temple at Thiruvananthapuram, allowing the appeal filed by the member of the Travancore family. The top court reversed the finding of the High Court of Kerala that the rights of the family ceased to exist with the death of the last ruler of the Travancore in 1991. The death of the last ruler will not result in the issue of the rights in favor of the government. The Supreme Court has upheld the right of the Travancore royal family to manage and control of the Padmanabha Swami Temple in Kerala. The order was passed by a bench of Justices U.U. Lalit and Indu Malhotra. The verdict was on the dispute on whether the control of the Padmanabha Swami Temple in Kerala will vest with the state government or the Travancore royal family. The bench held that the death of the King of Travancore, who signed the covenant, does not affect sabbateship, which means management and maintenance of the idol of the Travancore royal family. The court thus gave the note for the constitution of an administrative committee which will manage the affairs of the temple. The district judge of the Thiruvananthapuram will be the chairperson of this committee. It was further specified that all members of the Padmanabha Swami Temple committee will be Hindus. The temple was controlled by a trust headed by the Travancore royal family up till April 2014, when the Supreme Court, by an interim order, directed its management to be taken care of by a four-member administrative committee headed by a district judge. The bench held that this interim arrangement would continue until the committee is constituted. On the questions of the Vault B of the temple should be opened, the court stated that the same would be decided by the committee. The appeals before the Supreme Court were filed against a 2011 Kerala High Court judgment directing the state government to take over control of the Sri Padmanabha Swami Temple, its assets and management. The matter was pending for over 9 years. The Kerala High Court bench of Justices C.N. Ramachandran Nair and K. Surendra Mohan has ruled that the state government should take over the control of the temple from a trust headed by the royal family. The High Court has also directed the government to open all vaults, make inventory of the entire articles and create a museum to exhibit all the treasures of the temple for the public, devotees and the tourists. Viewing of the same could be arranged for on a payment basis in the temple premises itself, the court has ordered. On appeal against this verdict, the Supreme Court on May 2011 ordered a detailed inventory of the article at the temple, including the vaults, which had long rumored to be holding immense riches. When 5 of the temple's 6 vaults were opened after the Supreme Court orders, a vast treasure of gold and other priceless objects were discovered. It was estimated that the intrinsic value of the treasure amounted to more than rupees 90,000 crore. One of the vaults could not be opened. The opening of the same was later kept in abeyance by the Apex Court. Senior advocate Gopal Subramaniam was appointed as the amicus curiae in the matter. Former CAG Vinod Rai was also appointed to audit the records, including expenditure incurred for the temple's maintenance. The case has its roots in 2009 when T.P. Sundarajan, a former IPS officer, filed a public interest litigation petitions before the Kerala High Court, praying that the control of the temple should be handed from the royal family to the state government. The primary legal documents before the Apex Court Court was the Agreement of Accession, agreement signed between the kings of the Travancore and the Government of India in 1949, by which the princely state of Travancore became a part of the Indian Union. Bureau Report. Farooq Abdullah and Omar Abdullah have approached the Jammu and Kashmir High Court for the release of 16 National Conference leaders detained since August 5 last year. In the petition, the National Conference has termed the house detention of these leaders as illegal. These leaders were detained at their home last year when the centre abolished the special status of the state. The statement issued by the party said that Farooq Abdullah and NC Vice President Omar Abdullah have filed habeas corpus petitions challenging the illegal house detentions of senior leaders and office bearers. Former State Chief Minister Farooq Abdullah has petitioned for the release of Ali Muhammad Sagar, Abdul Rahim Rada, Nasir Aslam Wani, Aga Said Muhammad, Muhammad Khalil, Band Irfan Shah and Shah Amina Fardous. During a hearing on Delhi riots in Delhi High Court, Delhi police had said that all the hate speech is being examined and necessary action will be taken if connection is found between the hate speech and violence which followed. The statement is in response to a prayer for registration of the FIR against the political leaders Sonia Gandhi, Kapil Mishra, Anurag Thakur, Akbaruddin Owaisi and others for hate speech in relation to the Delhi riots. In response to one of the Delhi riots petition, the Delhi police has told the High Court that all hate speeches are being examined and necessary actions will be taken if a nexus with the riots is found. The submission was made in the petition seeking registration of FIR against political leaders Sonia Gandhi, Kapil Mishra, Anurag Thakur, Akbaruddin Owaisi and others for hate speech in relation to Delhi riots that occurred in March this year. The statement forms part of the common counter affidavit filed by the Delhi police through Advocate Rajat Nair in response to all the petitions concerning the Delhi riots. Delhi police said that Additional Commissioner of Police is examined all hate speeches and if it is found on evidence that their speech had any nexus with the riots which have occurred in New Delhi, appropriate actions would be taken accordingly. In response to another petition which seeks FIR against BJP leader Kapil Mishra, Anurag Thakur and Parvesh Verma, the Delhi police had said no fresh FIR is warranted at this stage against them and as and when substantial and cogent evidence of their involvement is in any offence emerges, suitable steps will be taken in furtherance of the already registered FIRs. Stating that 751 criminal cases have already been registered in Northeast District related to the violence riots and 3 special investigation teams have also been constituted to carry out the investigation, Delhi police had said. In its affidavit, Delhi police has sought the dismissal of all the writ petitions on the ground that it was impermissible in law to seek interference of the court in a criminal matter in the garb of PIL. It is reiterated that as per prima facie investigation, the riot was not a case of any sporadic or spontaneous violence, but appeared to be a part of the conspiracy to destabilize harmony in the society. Bureau Report. The Supreme Court has granted 1 week time to the Centre and Union Territory of Jammu and Kashmir to file their reply in the plea seeking contempt allegations, non-compliance of the May 11 judgment of the Supreme Court, which had directed a special committee be constituted to immediately determine the necessity of the continued restrictions of the mobile internet speed in Jammu and Kashmir to 2G only. A bench of Justices N.V. Ramana, R. Subhash Reddy and B.R. Gavai refused to issue notice in the petition filed by the foundations of media professionals alleging contempt for the inactions of the Secretary, Ministry of Home Affairs and Chief Secretary, Union Territory of Jammu and Kashmir. The Supreme Court sought the central government's response in a plea seeking initiation of the contempt proceedings against the authorities in relation to the suspension of internet services in Jammu and Kashmir. The court, however, refrained from issuing notice in the matter. The special 3-judge bench of Justices N.V. Ramana, R. Subhash Reddy and B.R. Gawai was hearing a contempt petitions filed by foundations for media personals, alleging the authorities' failure to constitute a special committee to review the ban on 4G internet in Jammu and Kashmir in accordance with an earlier order of the Supreme Court. The court at the outset told Attorney General for India K.K. Venugopal and Solicitor General Tushar Mehta that if decisions pertaining to the internet speed restrictions are taken by the designated committee, the same need to be placed in public domain. In the plea seeking initiations of contempt proceedings against the government, the petitioners have contended that there is no information available in the public domain as regards setting up of the review committee as was directed by the court earlier. However, S.G. Mehta told the court that not only has the committee been set up, decisions have also been taken and reviewed. Senior counsel Huzaifa Ahmadi, on behalf of petitioners, sought to counter Mehta's submissions and argued that several orders for suspension of internet services in the regions were passed between the May order of the Supreme Court and the time of filing the instant plea. The concerned authorities are not responding to representations made by the aggrieved persons against internet suspensions orders, Ahmadi added. Attorney General G.K.K. Venugopal, however, said that the questions of contempt does not arise as the committee in questions had already been set up. The bench was quick to point out that the details of the committee were not in the public domain and asked the government to file its counter affidavit on the plea in a week's time. In its May 11 judgment, the Supreme Court had directed that a special committee be constituted to immediately determine the necessity of continued restrictions of mobile internet speeds in Jammu and Kashmir to 2G only. The central government had imposed a complete communications blackout in the erstwhile state of Jammu and Kashmir in August 2019, right after abrogations of Article 370. 5 months later, in January 2020, on the basis of a Supreme Court order, the services were partially restored, only at 2G speed for mobile users. Access was provided only to selected white-listed sites and social media was completely blocked. Bureau Report. The Supreme Court has refused to hear a petition challenging the 100% domicile reservations in the public employment brought in by the Jammu and Kashmir Reorganization Act 2019 post the abrogations of the Article 370. The bench of Justices L. Nageshwara Rao, Hemant Gupta and S. Ravindra Bhatt took up the plea for hearing today via video conferencing. However, it refused to entertain the same. The apex court granted liberty to the petitioners to remove the Jammu and Kashmir High Court and exhaust that opinion first before approaching the Supreme Court. The plea states that Parliament never delegate law-making powers to the centre under Article 16(3) of the Constitution. The petition has assailed Sections 3A, 5A, 6, 7 and 8 of the Jammu and Kashmir Civil Services Decentralization and Recruitment Act 2010 as being violative of Article 14, 16, 19 and 21 of the Constitution. The Union Ministry of Home Affairs under Section 96 of the Jammu and Kashmir Reorganization Act has amended Jammu and Kashmir Civil Services Decentralization and Recruitment Act, whereby the term permanent resident of Jammu and Kashmir was replaced with domiciles of Union Territory of Jammu and Kashmir. Furthermore, the amendment included a selection of 3A by which children of this central government officials who have served in the erstwhile states of Jammu and Kashmir for a total period of 10 years were included as domiciles of the new UT. Another Section 5A stated that no person shall be eligible for appointment of any post unless he is a domicile of Jammu and Kashmir. Citing Section 5A, the petitioner states that the new amendment would render guarantee of equal opportunity under Article 16(3) meaningless and illusory. The petitions averse that since all laws and Supreme Court judgment applicable to India are now extended to the UT of Jammu and Kashmir, and since, as per the Article 16(2) of the Constitution, no citizens shall be discriminated on the basis of residence, the amendment made by the centre under Article 16(3), which allows domicile or resident-based reservation, was beyond its authority. Senior advocate Raju Ramachandran and advocate Archana Pathak Dev has moved an application before the Supreme Court making recommendations for effective implementations of the court's guidelines pertaining to police reforms in Prakash Singh and other versus Union of the India. The application contends that till date, the guidelines issued in the 2006 Prakash Singh judgment have not been effectively and completely implemented. Ramachandran and Dev, both amici curiae in the case, have pointed out in the application that either the state government have not brought in the requisite legislations for police reforms or the legislation passed in this regard are under challenge before the courts. The purpose of filing this application, it is said, is to eliminate the need for continuously filing applications when the state-specific situation arises. The guidelines laid down by the apex court in Prakash Singh were to be followed till appropriate legislation was brought in. These guidelines touch upon separations of the law and order and investigation wing of the police, fixing a minimum tenure of personnel, setting up of police complaints authority. As such, for effective and speedy implementation of these guidelines, the amici have the following suggestions. The jurisdictional high courts constitute dedicated benches to determine the extent to which compliance by the executive orders have been made by the concerned states or union territories. Individuals' applications pertaining to the state union territories concerned may be dealt with by the state benches having made the suggestions. The amici have sought for an early date to be fixed for hearing and adjudicating the matter in which the constitutional validity of the concerned state legislation is involved. A date for hearing of the contempt plea which bring forth the issue pertaining to the IPS cadre amendment rule is also sought in the application. Jammu and Kashmir High Court has asked the Sri Amarnath Shrine Board and Union Territory government to urgently take all decisions regarding the conduct of the Amarnath Yatra in compliance of the top court's decision of July 13, taking into consideration all relevant issues as also the several concerns. Hearing a plea on Amarnath Yatra, a division bench of Chief Justice Geeta Mittal and Justice Sanjay Dhar of Jammu and Kashmir High Court specified that the decision shall ensure compliance of all healthcare protocols, standard operating protocols notified by the central government as well as by the Union Territory of Jammu and Kashmir, guided by the principles laid down by the Supreme Court of India, that the right to health of every person has to be placed at the highest pedestal. Besides, any such decision taken must address the concerns of health of the security personnel, healthcare personnel, priests, the yatris and of the officials who would be involved in the arrangements and conduct of the yatra, as also the residents of the Union Territory of Jammu and Kashmir. At the same time, the board is directed to ensure considerations of the welfare and support of all persons, especially the members of the communities, particularly the Bakarwal community, who provide the porterage, pithos, palkis, mules and horses, and who provides services on the yatra. The bench observed that the movement on the yatra track, even without the pandemic situation, is a challenge at any point of time, even for the able-bodied and the healthy. It appeared to the court that it would be impossible to deal with infection on the track. The Supreme Court had earlier refused to entertain a petition seeking to stop the yatra, observing that the local administration was better equipped to take a decision on the same. Inasmuch as it was urged before the High Court that the Supreme Court had last month permitted the Jagannath Yatra in Orissa, the division bench opined that it must be cognizant of the stark difference in the two yatras. Whereas the yatra at Puri is in the heart of a main city, the Sri Amarnath Ji Yatra is over extremely difficult terrain, undertaken on a rough and narrow hilly track at extremely high altitudes. The attention of the bench was drawn to the threat to the health and lives of the defense forces, security personnel and police on account of the exposure to the reasonable possibility of COVID-19 infected person who may join the yatra, perhaps unaware that they are infected as they remain asymptomatic. Noting that the decisions regarding the conduct of the yatra are being taken by the Sri Amarnath Shrine Board, which is chaired by the Lieutenant Governor of the Union Territory of Jammu and Kashmir, the High Court required that copies of the applicant before it. The Jammu and Kashmir High Court clarified in case the decision taken is contrary to the parameters laid down by the Supreme Court in the judgment dated 13 July, it shall be open to the applicant to invoke the appropriate remedy in accordance with law. The Sri Amarnath Ji Yatra for the year 2020 was scheduled to begin on 23rd June, Skand Shashti, and to continue till 3rd August. Bureau Report. The Uttar Pradesh police has informed the Supreme Court that Vikas Dubey had never surrendered but was nabbed after a tip-off from the Madhya Pradesh police. It was stated that the encounter took place after Dubey opened fire at its police officials in an attempt to flee on July 14. The Supreme Court has sought a response from the state of Uttar Pradesh on the plea seeking a prop into the encounter killing of gangster Vikas Dubey. The bench headed by Chief Justice of India S.A. Bobde had also hinted at setting up a committee to look into the matter. The UP police, through its standing counsel Advocate Garima Prasad, has submitted that the state authorities have strictly worked in accordance with the law and guidelines laid down by the Supreme Court in the PUCLV Union of India in 2014. It was further averred that the authorities have also intimidated the National Human Rights Commissions within 24 hours of the incident, which clearly shows a lack of malafide. Substantiating reasons on why the encounter took place on July 10, the UP police have stated that motive of Dubey was to not only flee but also to kill the policeman and create terror in the mind of the people as well as the police. The police has categorically stated that Dubey did not surrender. On July 9, Dubey was identified by Mahakal temple authorities in Ujjain. After police verified his identity, Dubey was taken to the police station, reads the affidavit. The state police had also attempted to debunk the theory of Dubey being found to be traveling in two different cars. Police have submitted that Dubey had traveled from Ujjain to Guna in one vehicle, and after Guna, he was taken by the investigating officer in an SUV. He was also being transferred from vehicle to ensure security and alertness. Well, that's all in courts this week. Thank you so much for tuning in and keep watching APN and stay safe.